What is up, guys? I do hope you're well. My name is Mark and today we're covering r/legal advice. If you're new here, please consider hitting that like, that subscribe and maybe that notification bell too, as it really does help out our channel. And don't forget you can follow us on podcasts now too. And also, if you want to, you can support the channel on either Patreon or YouTube membership, where there's different tiers of support and different perks and things like that, such as membership videos. And with that being said, let's get into today's stories. Much love, guys. Our next story is from Masuka1219. Invested in a house with ex and his parents that the ex and I lived in. He cheated again. I left. They sold the house, gave me nothing and used the profits to buy him a different house. When my ex and I moved in together for the first time, after dating over 6 years, our credit was not good. His parents got a loan in their name to purchase a home. We put in all the money. Nothing was put into writing prior to the deal. Ex put in $17,000, I put in $7,000 towards a down payment and other expenses, inspections, earnest money, etc. I paid the mortgage every month we lived there at $13,000. I painted, purchased light fixtures and assisted in every step of the process when fixing up the house. Bought the house at $140,000. When we sold the house we owed $122,000 and they sold the house for $160,000. I got an email from the ex's mum prior to the sale going public saying they took a loss and no one was getting anything back. They claimed that they had put in $12,000, which is false, and that they were losing all of their money. The ex was losing all his money and so was I. Made me giggle. At the end of that email, she forgot to delete a sentence that from her draft saying, "You'll get $1,000 and nothing more." I got zero as they clearly changed their minds. Turns out I was the only one who lost all my money because they took all the profits from the sale of our home and used it as a down payment for a new house for him. Mummy and Daddy co-signed and bailed out their abusive, cheating, alcoholic son yet again from day one. The ex has lied, said he got nothing and is renting his current house. All lies. I have emails where he admits they were not supposed to put in any money, that the house was theirs in name only. She made up charges that I owe them like disposal of piano that I left at the house. The ex just admitted to keeping it as a project. I have receipts and cancelled checks. The mortgage company understood the arrangement, as did the initial realtor. Taking into account there was no contract between us. Do I have any legal recourse? In addition to the email where she generally admits the arrangement, I believe there is a good chance I could get the real estate agent to attest my version of the events. Side notes, not sure if any of this matters, but some additional detail. My new job had paid a total of $50,000 for me to move, and that included paying the portion of my previous mortgage that was upside down. The reason I left was he was an alcoholic and the relationship got progressively abusive. He was a serial cheater and I moved out specifically when I found out he slept with his co-worker while we were living together. Again, this was ongoing, in the parking lot of the building they worked in. Despite everything, I was trying to be fair and only asked for $4,000 from the sale, which was 1/3 of what I believed the profits to be after the ex and his parents got their money back first. I wasn't even including my initial $7,000 investment. They sold the house because the ex could not afford the $1,100 month mortgage. After I moved out, Mummy and Daddy paid the mortgage for him because he couldn't. I think you can gather from my post, I'm bitter. I'm pissed that he cheats, takes the money and now owns a home when I had to take a loan off my retirement to be able to get a security deposit so I could rent a place for my kids and I. Honestly, I don't need their money. It's not even about that anymore. I want vindication that I'm not crazy. I need someone else to see through their lies and gaslighting. Considering suing for $1 just for the judgment against them. Revolutionary Step 7 says, what state? I would try to sue them in small claims court. If your loss is over the small claims amount, then you have to talk to a lawyer to see if you should go to regular court. You are entitled to the $7,000 initial investment, it was not a gift. Where it gets muddy is trying to sue for the mortgage payments and share of the profit. You may not be able to win a case for those, but you should be successful suing for your down payment back. The OP replies, Illinois, and thank you for responding. A Superific replies, small claims in Illinois is a $10,000 limit, meaning that you can pursue that initial investment without a lawyer. If you want to pursue the mortgage payments and the like, you're going to have to sue with a lawyer. I'll consult with a lawyer to make sure you're dotting your I's and crossing your T's, but that's a far cheaper proposition than going to court with a lawyer. JRC 5053 replies, I am a lawyer, but I'm not your lawyer. I'm going to explain what each party did wrong or what obligations you may or have to each other. All of you screwed up and have opened up yourself to various liabilities. You should not pursue this by yourself. You would need to consult with an attorney to obtain any vindication you believe you deserve, while making sure you don't throw yourself under the bus because you made an emotional decision. It will not be cheap. OP replies, "Thank you. I have access to a lawyer through a work benefit. Prior to buying the house, I thought I had done sufficient research, but clearly I did not. I'm still stuck on people saying this was fraud. I literally told the lender that the real estate agent exactly what we were doing. I can't believe no one thought to mention that this was fraud/illegal. GRC 5053, the lawyer replies, "It may not be fraud. Random people on the internet don't know all the facts. That includes me. Some mortgage programs have exceptions allowing immediate family members of the borrower to reside in the property, therefore meeting the residency requirements of those programs. The fact that your ex was their son may have made it non-fraudulent action. Most people hear things and repeat them as gospel without knowing how to do legal research. This is why you should seek the advice of counsel to help with this. Your best course of action is maybe to let this go. Your time and money would likely be better spent moving past this and letting your ex and his family stew in the fact that you're happy and they're conniving hypocrites who got forgiveness they never deserved." You know, I'm nowhere a lawyer, but I've dealt with some legal stuff before. I'm currently dealing legal stuff with my own dad. But, you know, for $7,000 and the fact that you say that you're bitter and you just want to sue, maybe even for $1 just for the judgment against them, I say just let it go. You know, move on and just get those toxic people out of your life because they're clearly making you angry. Just try to forget them and move past it because I don't think, you know, I think it's going to cost more than $7,000 to even get it back from them. I'm not sure. As I said, I'm not a lawyer. But what do you guys think of this story? Let me know in the comments below. Our next story comes from Am I the One Who Posts? Newly formed church shooting range refusing to stop shooting in the direction of my own bordering property. Michigan. My family owns a decently sized piece of field/woodland in central Michigan, and we've resided there for many generations. Recently, the local church bordering our property started allowing people to use their land as a shooting range. However, the line of fire follows through to our land and the other side. They often use high-powered rifles that easily go through their plywood targets. We frequently drive through there with children and cannot abide the possibility that a stray bullet could hit one of them, so we need the shooting range to either point another direction, not likely if you look at the image, or halt firearm-related operations altogether. We're not able to access the full property without being in the line of fire. We have asked the church to move their targets to somewhere else, but they are saying the way they are currently shooting is the safest direction and will not cease firing. In addition, I've recently learned that they occasionally have hunters safety classes with a DNR officer present. Does that further legitimise their shooting range? As the church will not willingly stop, do I have any way to legally stop them from putting us in danger? And because I know how much you're like poorly drawn pictures, here is the situation graphically represented. Happy to offer any additional details. My family seems to mostly think we have no recourse, but that didn't sound right to me at all. I appreciate any advice you can give. Firstly, let's get a church shooting range. What the hell is going on? How can they have a church shooting range and it going on someone's property that could potentially kill someone? What the fuck? The first comment is from True Man. Get a lawyer to write them a nasty gram. They are liable for every bullet that leaves their property. They need to build an earthen berm in order to limit their liability. There may be state requirements that they're ignoring if they're operating and organising a gun range that serves more than just a familial unit. Again, find a lawyer versed in such issues. The OP replies, could I notify their insurance that they are operating a gun range? I doubt they have that disclosed. Maybe I can make it too expensive. If so, does anyone know how to go about doing that? Is your insurer publicly available information? Or CCC replies, you may want to go to your city hall and innocently start asking for their permits to construct and operate the range. Shocking a bureaucrat with news of another person's malfeasance can often jumpstart action. You should also inquire about the zoning of the land where the range is. If you pull the property tax records for the land, usually a county office or website, you could find the landowner or mortgage holder. They won't be too happy with the extreme level of negligence being practiced on the property they technically still own. OP quotes the last comment and says, I like the suggestion, but it may not work in this instance. This is one of those very small towns where everybody knows everybody, and I believe it's more likely that the 3 people at the town office would fall in cahoots with the church instead, as they are all members. And I'm not sure about zoning, but I do know the church owns the land as my late, devoutly religious grandmother sold it to them before she passed. There was nothing in the deal regarding the shooting range, however. I can check out the zoning though, thanks. What about going to the county office? OP says, might be an option. Do they have the same powers? Yes, county ordinances overlap city ordinances. Also, you inquire with the county sheriff about the range. Not having a dirt backstop is just plain criminal negligence. Unfortunately, it will not be recognised as such until the unthinkable occurs. There is a very large difference between small caliber target shooting, .22s, and large caliber weaponry. Not having a dirt berm is absolutely unthinkable. You might also approach the DNR office, asking how they can support a rifle range with no backstop, placing the general public in harm's way. Also follow up with the State Attorney General's office, in that if something were to happen with a DNR officer present, state liability for criminal manslaughter would be large. I do think that if you can find the church's insurance company, they will be very unhappy about the situation. I mean, looking at that picture, as they said, it faces the access road. So if someone's driving down the road and they're shooting, there's a good chance that they could get shot. I mean, what the fuck? This is a church. What am I missing here? How can they think that's okay? The shooting range should not be in that area, period. Look, it's property all around it, then there's residential and a main road on the other side. There is nowhere to be shooting rifles. Jesus Christ, man. Let's just hope something does get done before someone gets shot. Jesus. What do you guys think of this story? Let me know in the comments below. Our next story comes from Lucky the Lurker. Someone euthanized my daughter's horse without our permission. This is in the US. It may hit the news, but I'm intentionally being vague as to respect the parties involved if we can resolve the issue out of court. We have a few horses stabled at the local equestrian centre. They went through a change in ownership and we have been vocal about some of the changes. Last week my daughter's foal Morgan died suddenly. The horse had a recent checkup with no issues. Morgans are usually a very hearty breed, so its sudden death was suspicious, so our insurance company ordered an autopsy. We had some issues with the equestrian centre wanting to dispose of the animal, but I think it was purely the fact that they aren't set up for storing dead horses long term. The autopsy came back today and the horse tested positive for a number of drugs commonly used to euthanize horses. This creates a number of issues. A. Who killed the horse? This is now an animal welfare issue. Was it a mistake somehow, or was it intentional? B. What do I do about the other horses? We have a contract, but I think under the circumstances, I am willing to pay the cost to break it. I asked the insurance company if I can move them to another stable, and they said okay. I don't know if the police are involved yet. C. Should I engage an attorney yet, or wait for the insurance company to finalise their investigation? I'm definitely going to sue the stables for allowing this to happen. My daughter is devastated. She got that horse from her grandfather shortly before his death. Should I also be concerned about potentially being investigated by the insurance company? Who the fuck kills a horse? Update, I've retained a lawyer referred to me by my business lawyer. He will be my point of contact for the insurance company and the stables. He's reaching out to the stables to inform them I will be removing my horses for their safety, pending the ongoing investigation. My horses will be going home this evening. Some of my daughter's friends have stepped up and offered to take care of our horses until we can get them boarded. They are reliable and even offered to transport the horses. The lawyer said it's likely my insurance won't pay for the loss of the horse, but we'll need to file a suit against the equestrian centre. He's read the preliminary report from the insurance company and the toxology report. I misunderstood the terminology when they first told me the results. I was truly upset about the horse, so I'm not surprised I misunderstood. It appears that the horse died from ingesting tranquilizers and other medication. It is possible it is accidental, but also possible it is malicious. The equestrian centre has a capacity of over 50 horses, so they have an on-site vet, and they do stock drugs. We don't know if their stock is the source, but it's likely. Thanks for everyone who's been supportive. This is a nightmare. Less of me, more of him replies, what a horrible thing to have to go through. I feel so sad for your horse and your daughter, especially. Thank God for your insurance company deciding to investigate the suspicious death. I'm not a lawyer, but in addition to CT 8905's suggestion for what you should sue them for, it comes down to that you might want to think about tacking on the cost of move and board them elsewhere, and if the new stables are more expensive, maybe it's possible to sue them for the difference in price for the length of the contract you are now forced to break. I agree with CT 8905, you absolutely should not pay to break the contract. None of this is your fault, so you shouldn't have to shoulder any financial burden. Hindsight DJ says, I'm so sorry for you and your daughter. As a former horse owner, this infuriates me beyond reason. 1. Retain a lawyer. Will your insurance company out there? Can't hurt to ask if they smell money. 2. Obtain an expert witness. Regional, state vet offices, Department of Agriculture vet offices are a great place to start. 3. Review your findings of the test with the experts. Have your lawyer/expert reach out to the local vet offices. This is most likely euthanol, which is a Schedule 3 controlled substance in the US. This came from someone who had access to this drug. If the horse is tested positive for phenytoin or pentobarbital, I don't know if I pronounced those correctly, sorry. Oh, and have your lawyer scan the lease/contract. I'd be getting my other animals the hell out of there yesterday and worrying about those details down the road. Payments, owing, etc. I'm not a lawyer, but I did go to vet school for a time. Good luck. You gotta feel sorry for the daughter in all this badly, but the horse that the grandpa gave her. But what do you guys think of this story? Let me know in the comments below. Anyway guys, that is it for today's story. I hope I did legal advice a little bit better this time around, and I hope you did enjoy it. If you did, you know what to do. Click that like, that subscribe, and maybe that notification bell too, as it all truly does help out our channel. And there's another video on your screen as we speak. And if you fancy clicking that, well, why the hell not, right? Enjoy, and I will see you in the next one. Much love, guys.